Hello, and welcome to California Gun Law. I'm your host, Don Hammond, with an update on 4 new California gun laws and a new lawsuit already challenging the Glock ban before it takes effect. All 4 new laws passed the legislature last month, and Governor Newsom signed them on Friday and Saturday. We'll discuss what these bills do, when they take effect, and the next steps, including one lawsuit already filed. I'm a licensed California attorney and a shooting instructor. I regularly help teach the 16-hour class that's required to get a concealed carry license in California. On this program, we provide education on California's complicated web of gun laws so that responsible gun owners like you can better understand how to lawfully exercise their rights. California has a complicated web of firearm laws and regulations, and there are a lot of traps for the unwary. We want to help you do it right so you won't need our criminal defense legal services. Today, I'll discuss updates to 4 different new gun law bills. We'll discuss their implications and current status. We're going to discuss Assembly Bill 1127 regarding a ban on sales of Glock and Glock clones, and the details of a new lawsuit to block its implementation. Assembly Bill 1078, which updates California's CCW laws in several key respects. Senate Bill 704 will require all transfers of firearm barrels to go through an FFL in a face-to-face transaction. And Assembly Bill 1263 makes it a crime to 3D print a gun in California or aid anyone who does. All of these bills passed the legislature last month, and the governor signed them this past Friday and Saturday. So first up, let's talk about the so-called Glock ban bill, Assembly Bill 1127. It passed both houses of the legislature back on September 12th, and the governor signed it on Friday, October 10th. So new sales of semi-automatic machine gun convertible pistols will be banned beginning on July 1st, 2026. This includes any pistol with a cruciform trigger bar, which includes Glocks and Glock clones, such as Shadow Systems pistols and some others. You will still be able to keep any Glocks that you already have, and you can private party transfer them, but you won't be able to buy a new one in California after July 1st, 2026. Let the litigation begin. The NRA, along with the Firearms Policy Coalition and the Second Amendment Foundation, have already filed a lawsuit against Attorney General Rob Bonta for an injunction against enforcement of this new law. The case is James versus Bonta, filed yesterday in the Federal District Court for the Southern District of California down in San Diego. Glocks are one of the most popular handguns in the world, and they're definitely in common use, which is the test under Heller for whether they are protected by the Second Amendment. I'm sure we'll see a preliminary injunction battle soon, and we'll keep you updated. The plaintiffs have already filed a notice of related cases to try to get this case to the same judge that is presiding over the Rina v. Bonta case regarding California's ban on some specific Glock models. In that case, the judge issued a preliminary injunction a couple of years ago, but that's up on appeal to the Ninth Circuit right now, and we're expecting a decision whenever they get around to it. The next bill is Assembly Bill 1078, which is a mixed bag that we've talked about quite a bit already. It prescribes a statutory process for sheriffs and police chiefs to issue non-resident CCW licenses, bringing statutory law into compliance with injunctions in the CRPA versus LASD and Hoffman versus Bonta cases. The new law also clarifies that out-of-state equivalents to California disqualifying convictions or restraining orders are also disqualifying. One key provision clarifies that a temporary restraining order issued without notice in a hearing is not a disqualifying criteria for getting a CCW license in California. The bill will also mandate that agencies shall not issue a CCW license if the applicant has knowingly provided inaccurate or incomplete information on the application. So we'll see even more denials for failure to disclose information, and those denials will be more difficult to challenge in court. On another note, Assembly Bill 1078 also creates a new 3 in 30 rule for gun purchases. So until a court strikes it down, California residents will be able to purchase a maximum of 3 firearms every 30 days. This seems to fly directly in the face of the recently published decision in Nguyen v. Bonta by the Ninth Circuit. That decision is final and citable, and it held that the state cannot meter a constitutional right. Seems pretty clear to me. AB 1078 passed the legislature on September 9th, and Governor Newsom signed it on Friday, October 10th. So this bill will become law and take effect on January 1st, 2026. Next up, Senate Bill 704 will require all transfers of firearm barrels to go through an FFL in a face-to-face transaction. The new requirements take effect on July 1st, 2027. This passed the legislature on September 9th and was signed by the governor on Friday, October 10th. This bill is designed to combat home printing of ghost guns because it's much more difficult to print a barrel at home versus any other part of a firearm. Unfortunately, while limiting ghost guns may seem like a noble goal, it throws the baby out with the bathwater. So we won't be able to order barrels off the internet and have them directly delivered to our doors anymore. Although I don't see an importation ban in this new law, so we should still be allowed to buy barrels out of state and bring them into California, at least until the legislature realizes they left that open. Don't tell them. Finally, Assembly Bill 1263 is a straight-up ban on 3D printing guns. It criminalizes causing another person to print them or aiding and abetting a person printing. So even sharing data files for someone else to print a firearm will be a crime. The bill also creates a civil cause of action against people who print firearms. And it makes anyone convicted of a variety of misdemeanor firearms offenses a prohibited possessor for 10 years. This includes any conviction for illegally manufacturing firearms or magazines using a 3D printer or otherwise. This list of misdemeanors that make people prohibited keeps growing every year. This bill passed the legislature on September 11th, and the governor signed it on Saturday, October 11th. So this bill will take effect on January 1st, 2026. So that's 4 gun bills, implementing a wide variety of new laws. California keeps adding more gun laws that convert law-abiding gun owners into criminals. And many of the new laws come with provisions that make you a prohibited person for 10 years for even a misdemeanor violation. I see a lot of people in my comments saying they won't comply with the new laws. Well, it's pretty hard to not comply when an FFL won't sell you a Glock, or when an online retailer won't mail you a barrel. And as a lawyer, I'll tell you that non-compliance with California's gun laws can get expensive very fast. And perhaps more importantly, it can cost you your right to possess firearms under the ever-growing list of misdemeanor convictions that would make you prohibited for 10 years. What do you think? Are you stocking up on Glocks and barrels before these new laws take effect? Some people think that non-resident CCW license applications are clogging up the system and delaying processing of California resident applications. Let us know your thoughts in the comments. And head on over to cagun.law for legal updates and to pick up some cool merch to support the cause. I'm Don Hammond at California Gun Law. We'll catch you all next time. Stay informed, stay legal, stay safe.